Senator Elizabeth Warren has introduced legislation that would effectively ban large tech mergers. It's called the Prohibiting Anticompetitive Mergers Act. The simplified interpretation of this legislation is that it would break up anything that's big, and it would prevent anything from becoming big anytime in the future. Will this legislation solve any real issues, or will it cause more problems than it solves? And if you could vote directly on this legislation, would you vote for it or against it? If you're new to my content, One Direct Democracy is a movement for upgrading the global democratic system by taking power away from politicians and putting it in the hands of the people with direct democracy. It'll also eliminate left and right-wing politics. I've created the technology and a specific plan for how to make it work. If you want more information, check out the links in the description. For each episode, I'll pick an important issue, outline the problem, talk about the solutions, and you can decide how you would vote. In this video, we'll be talking about whether mergers between large companies should be banned. Before we get into any detail, let's try to understand where Senator Warren is coming from. I'll be referring to articles from Engadget and from Vox. Her new bill, the Prohibiting Anticompetitive Mergers Act, doesn't just break up big tech, it breaks up big everything, and it prevents companies from getting too big in the future. It would also fundamentally change how agencies evaluate and block proposed mergers, a process that currently gives companies a lot of power and agencies relatively little. Warren says the bill crystallizes her vision for how government can stop industry consolidation that has broken America's markets, hurt its economy, and threatened its democracy. So as far as I can tell, there is an underlying philosophy to break up anything that's big and to prevent anything from becoming big in the future. So what is this bill actually proposing to do? The Prohibiting Anticompetitive Mergers Act will make it illegal to pursue prohibited mergers, including those worth more than $5 billion, or which provide market shares beyond 25% for employers and 33% for sellers. So the assumption here is that mergers that meet these criteria will be anti-competitive. Is that a valid assumption? The bills would also give antitrust regulators more power to halt and review mergers. They would have authority to reject mergers outright without requiring court orders. So there will be no legal process. The regulators will just decide in their infinite wisdom whether a merger is anti-competitive. So let's understand how it works now and how it will change. The Prohibiting Anti-Competitive Mergers Act also fundamentally changes the agency's merger review process and power. Right now, if companies want to merge, it's on the FTC or the DOJ to make a case for why they shouldn't, and they have to sue the companies to block them. The onus is entirely on the agencies, which oversee thousands of mergers a year. With relatively little in resources, they can only challenge a few of those mergers. Doing so may mean a long court battle that's difficult to win. So Warren wants to swap the burden of proof from being on the government to being on the companies. With Warren's bill, it's the companies that have to do the work. They have to show that their proposed merger won't harm competition, consumers, and the labor market. If they can't, the agencies have to reject it. The companies have to sue if they still want to merge. Ideally, companies will try to merge less, and the mergers that they do try won't be harmful. The legislation is not just targeting mergers worth more than $5 billion. They would likewise bar mergers from companies with track records of antitrust violations or other instances of corporate crime in the past decade. Officials would have to gauge the impact of the acquisition on labor forces, which wouldn't be allowed to negotiate with companies to secure remedies for clearing mergers. Meaning that if the companies could adjust the deal terms in a way that makes the transaction not anti-competitive, they still wouldn't be able to do it. Crucially, PAMA would formalize procedures for reviewing past mergers and breaking up harmful deals that allegedly hurt competition. The Federal Trade Commission has signaled a willingness to split up tech giants like Meta, despite approving mergers years earlier. PAMA might make it easier to unwind those acquisitions and force brands like Instagram and WhatsApp to operate as separate businesses. This is obviously the most unusual and controversial part of the policy. It's not clear whether regulators can make these decisions with or without a court order. This act isn't strictly focused on tech, but Warren made it clear that the industry was a target. She cautioned the FTC on Amazon's proposed buyout of MGM Studios and challenged Lockheed Martin's since abandoned attempt to buy Aerojet Rocketdyne. Now, Amazon didn't have a studio before buying MGM, so I don't see how this can be anti-competitive. If it becomes law, PAMA would ban the Amazon-MGM union, worth over $8.4 billion, Microsoft's Activision deal, worth $68 billion, and relatively modest acquisitions like Google's planned buyout of Mandiant, worth $5.4 billion. Tech firms would largely have to focus on acquiring small companies, and would largely have to forego deals meant to expand market share or otherwise cement dominance in a given market. Okay, so this is my personal opinion on this issue. Firstly, this legislation makes an assumption that companies are made up of business units that can simply be removed anytime a regulator decides to tell them to do it. That's not really correct. Secondly, if companies know that a deal might end up being reversed after it was approved, there'll obviously be less deals. Third, all mergers are not the same. Senator Warren's proposing these rules in order to avoid anti-competitive behavior. But these rules will also stop mergers that increase competition, create jobs, and save companies. These rules are also obviously an extension of existing antitrust rules, but they don't seem to explain the exact problem with the existing rules and how these new rules will address those problems. The reality is that some mergers are very good for consumers and employees, and in some cases they even prevent one of the companies from going bankrupt. As far as I'm concerned, every merger needs to be reviewed individually and assessed on its merits. I've created a listing on the One Direct Democracy platform so that we can develop ideas about how the Prohibiting Anticompetitive Mergers Act can be improved. You can add your own ideas or vote and comment on ideas from other people. You can also create your own listings for people to vote on. It's a simple way to get used to using the One Direct Democracy system. The links are in the description. So that's a summary of the key issues. If you could vote directly on this legislation that proposes to ban large mergers and potentially break up large companies, would you vote for it or against it? Let me know in the comments. The reality is that we've reached a point in time in our evolution where representative democracy no longer serves the will of the people. That's why I created One Direct Democracy. It's a movement for upgrading the global democratic system by taking power away from politicians and putting it in the hands of the people with direct democracy. I've created the technology, a framework for direct democracy, and a plan for how to make it work. And we don't have to convince any politicians or powerful people to do anything to make this happen. We have the power to make it happen on our own. We just have to decide to do it. If you have no idea what I'm talking about, or you want more information about me or One Direct Democracy, check out the other videos on my channel and the links in the description. Direct democracy is the purest form of democracy. Representative democracy is an outdated, blunt instrument.